Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello and welcome to our March edition of our Labour Exchange podcast. I'm Clare Ward.
And I'm Leonie Mcquaide.
And today we're going to focus on the further and significant changes that have been proposed to the Employment Rights Bill, which have been laid down following the government's response to the various consultations that have taken place. We're then going to move on to do a bit of a deep dive on the Court of Appeal's decision in a recent and really important case, Morais and Ryanair, and Leonie's going to talk us through that. And fuller details of everything that we're going to talk about in this podcast can be found in our tracker that's updated regularly and our recent quarterly Labour briefing.
That's right, Claire. As you mentioned, the tracker is updated frequently, so it's a really useful resource given the fact that the Employment Rights Bill could well change again before it becomes law. So there's quite a bit that's changed in relation to industrial action, isn't there, Claire?
Yeah, that's right. So the amendments have changed many of the bill's provisions on industrial action, and they've added some new measures that have been proposed really via the consultations. So when you take all that together in relation to industrial action, the bill will repeal those minimum service levels that were introduced in 2023, and that'll happen immediately upon the bill becoming an act. They're going to repeal the 50% turnout threshold and the 40% support in important public services requirements. And that will mean that we will just revert to simple majority voting. So no requirement for a specific turnout, but there will be two different commencement dates. So that 40% support requirement in those important public services would be gone 2 months after the bill becomes law, whereas the 50% turnout threshold will only be removed once electronic balloting has been made available to trade unions, which the government has committed to making an option in either 2025 or 2026. They're also repealing the picketing supervision provisions that were brought in 2016 and reducing the information that a union must include on the ballot notice and sample voting paper. And that's quite extensive, so I'd encourage you to have a read of our briefing for full details of that. They're also reducing the information that will go to the union members with the ballot results, including that the number of individuals who were entitled to vote in the ballot will no longer be part of that information. The advance notice of industrial action is going to be reduced from 14 days. Now, that was originally proposed to be 7 days, but they seem to be landing in the middle. So that will be 10 days if these amendments go through as they're currently drafted. And the information contained in that notice will also reduce. Crucially, the ballot mandate will be extended to 12 months rather than the 6 months that we are at the current point in time. And also there will be protection introduced against detriment for taking part in industrial action. And that touches on that Morais case that you're going to talk us through in the second part of this podcast, doesn't it, Leonie?
Yeah, thanks, Claire. There's some really significant updates there. But for employers, what are the practical things that they should be considering now in light of these changes?
Well, basically, these changes will make it both easier and cheaper for unions to organise strikes. It'll also reduce the risks they face when doing so. They'll no longer have that same responsibility for the pickets, and the balloting and notification rules will be simpler, and there will be less scope for employers to challenge them. So it stands to reason, really, that there could be an increased amount of industrial action. And those changes will present employers with increased operational challenges. So, for example, reducing the information that's provided as part of that ballot notice and results and on the voting paper, and reducing the amount of notice that an employer will receive will make it more difficult for employers to contingency plan.
Thanks, Claire. And is there anything in particular that you would advise employers to be doing now to prepare for these changes?
Well, employers really ought to be auditing their IR strategy and their dispute resolution procedures to really ensure that they're fit for purpose. They should be looking at the relationship that they have with their recognised trade unions with a view really to building an effective and strong IR framework in readiness for these changes.
Brilliant. Lots to think about, but there's some good news for employers around collective redundancy. Is that right?
Well, yes and no. The government has changed its thinking on widening the duty around collective consultation, which will, in respect of both collective redundancies, which also includes dismissal and re-engagements. However, it's not the case that the establishment test has just simply been reintroduced. There will be a two-limbed trigger for collective consultation. So it will be where there's 20 or more employees proposed to be dismissed within a period of 90 days at one establishment. That is coming back, but there's a second limb. So it will be or where employees are being made redundant at more than one establishment, there will be a trigger, and that will be a number higher than 20, but we don't yet know what that number will look like. And that will also mean that the trigger for submitting HR1s will also be amended. Crucially, the penalties will increase. They're going to double from a maximum award of 90 days to 180 days pay, so really significant.
Yes, definitely, and really important for employees that they get this right. So thinking it practically, what should employers be considering about these changes?
Well, that new second limb that will require employers to look across establishments. So for lots of organisations, that will be across different sites, across different business units that may be managed very separately. And that will mean that they'll need to monitor those proposals to dismiss across those establishments. So there'll need to be some mechanism in place to tot up those numbers, and inevitably that will result in more collective consultation exercises. So employers will need, I would say, more HR professionals who know how to run those collective consultation exercises. So there's an upskilling piece there. And of course, with the increase in the protective award, it becomes even more crucial that employers know how to properly comply.
Definitely. And do we know any more about the new right of trade union access, as this is an area which a lot of employers are thinking about?
That's right. Yeah. So what we know now is it's really what we predicted, that it won't just be physical access, it will be access and or communication with workers, which basically paves the way for unions to seek access to using employers' digital communication tools. Um, and one of the examples given by the government was that an access agreement may require, say, an employer to provide information to their workers via an all staff email.
Got it. Thank you. And what about any changes to statutory trade union recognition?
So the main focus really has been on the access arrangements and the unfair practice rules. And essentially they are being extended so that they apply at a much earlier stage in the process. At the moment, they only technically apply during the ballot period, but they would apply really from the point that the CAC accepts the application. And the test for determining whether or not unfair practices have occurred will be lowered, and the time limit for making complaints will be extended. There's some other really key changes as well. So the number of workers in the bargaining unit will essentially be fixed at the point where the CAC receives the application. So whilst it might go down, any workers who join the bargaining unit would not count for the purposes of the various decisions that the CAC has to make, and crucially, they wouldn't be entitled to vote in any ballot that's ordered. There's also some changes around the procedural timescales for agreeing access agreements, and also there would be permitted to be recognition applications where an employer has an agreement with a non-independent union that's been entered into following a formal request for voluntary recognition. So really, the changes are coming thick and fast, and so it's really important to keep up to date with what's going on. And you can do that by keeping abreast of our tracker that, as we said at the top, that is updated regularly. But there's one particular case that we wanted to delve into today, and that's the case of Morais, which relates to the interpretation of the blacklisting regulations during periods of industrial action. Leonie, can you give us an overview of what that's all about?
Yeah, sure. Thanks, Claire. So it's probably worth talking about the wider landscape before we launch into the details of this case. So we had the Supreme Court case of Mercer handed down in April last year. And in summary, this judgment said that trade union detriment protections under Section 146 of TULRCA did not extend protection during periods of industrial action. The Supreme Court held that the failure of the legislation to provide any protection against sanctions short of dismissal for lawful industrial action breached Article 11 of the European Convention of Human Rights. And according to the court, there was therefore a lacuna in protection during periods of industrial action.
And I just mentioned that the Employment Rights Bill is intending to address that lacuna by introducing additional protection against detriment for taking part in industrial action and strengthening the protection against blacklisting, which was in the original proposals, and the rules around automatic unfair dismissals for protected industrial action will be strengthened by abolishing the limit on protection, which is currently 12 weeks.
Yes, yeah, that's right, Claire. So the Employment Rights Bill does take strides to try and fill that gap. The Morais case did initially begin as both a trade union detriment claim under Section 146 and as well as a blacklisting claim. But following this Mercer judgment, the trade union detriment claim was unsuccessful and only the blacklisting claim continued.
So it's often quite useful and interesting to understand the facts of the case. That's certainly how I remember them, but also then what the judgment means for the interpretation of those blacklisting regulations. Can you talk us through that?
Yeah, sure. So in the Morais case, the employer withdrew discretionary travel benefits from pilots for a period of 12 months after they participated in industrial action. The pilots in the case argued that compiling the list to facilitate the withdrawal of these benefits amounted to a prohibited list under the blacklisting regulations. So, what do the blacklisting regulations actually mean? In broad terms, the regs prohibit lists which contain details of union members or those taking part in the activities of trade unions that are compiled with a view to being used for discriminatory purposes. In this case, the Employment Tribunal and the Employment Appeal Tribunal held that in taking strike action, the pilots were taking part in trade union activities for the purposes of these regulations. And as such, they found that the employer fell foul of the blacklisting regulations. The employer appealed this decision to the Court of Appeal, and the Court of Appeal has now dismissed that appeal, confirming that taking strike action constitutes activities of trade unions, which should be given its ordinary meaning. This includes action organised or endorsed by trade unions, whether or not the union has complied with the legislative balloting and notification requirements. As such, the production of a list by the employer to identify the individuals who had taken strike action in order to withdraw the travel benefits was found to amount to blacklisting under the regulations.
That's really interesting, but it feels like it's quite different to the decision compared to the Supreme Court in the Mercer case, which is a case we've talked about on these podcasts. And in the Mercer case, it was concluded that the protection under Section 146, so the trade union activities detriment protections, didn't extend to periods of industrial action, because industrial action didn't amount to a trade union activity that was taken at an appropriate time. And I understand that in the Morais case, the employer's argument was that a consistent approach should be taken between the legislation that was the subject of the Mercer case and then this case that was in relation to blacklisting. But my understanding is that that was rejected by the Court of Appeal, and they took the view that the Mercer case could be distinguished. So it feels and appears that the Court of Appeal in Morais have interpreted the blacklisting regulations widely. Are there any key takeaways for employers, Leonie?
Yeah, definitely, Claire. So I think the key takeaway is employers should exercise caution if they are compiling lists of striking workers during periods of industrial action, and consider if any of the lists are compiled for a discriminatory purpose, as there is a risk that they could fall foul of these regulations. And this is quite a significant issue, because where a claim is upheld, the minimum award of compensation is £5,000, which can be subject to adjustments. So but it's not an insignificant sum. So it's definitely something that all employers need to be live to if they are experiencing strike action.
And of course, ordinarily, it's not one individual that's bringing the claim. It's supported by the union and brought on behalf of often a significant number of claimants. So that £5,000 can really quickly multiply up into a really scary number.
Exactly, definitely.
So I understand that the employer has applied for permission to appeal to the Supreme Court. So we're still slightly in a watch this space position. And of course, we're also awaiting further clarity on exactly how the additional protections will be implemented by the Employment Rights Bill. So it is a bit of a watch this space, but certainly one for employers to keep track on. So that brings us to the end of what we wanted to have a chat about today. So thank you for listening, and hopefully you'll join us next time.
Thanks, everyone.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.